the first meeting on the road, if you will, of the Child Abuse and Child Protective Services Law Task Force. And we are in a magnificent facility here at the University of Pennsylvania Law School. And I'd like to introduce our host. I was telling him that he's the first law school dean I've met since my law school dean, and I already like him a lot better. But then I didn't see that much of my law school. But if they had wonderful facilities like this, I might have. I think it's remarkable and unique in my experience that we're about to be greeted by the gentleman for whom this facility is named, which usually would only happen, I suspect, posthumously. So, Dean Fitz, you are obviously a paragon, and the floor is yours.
Well, Mr. Chair, thank you. The chairman, of course, remembers me more fondly than his dean from law school at UVA, simply because I agreed I wouldn't call on him at the meeting today. We are all prisoners of our first year in law school. But in any event, it really is an honor to welcome you all here. And thank you, Mr. Chair, who all of you have an incredible task before you. There's no issue, I think, today more important than the issue of protection of children and the abuse of children, an issue which we're not fully aware of the extent of the problem, but we know it's very severe. We know a lot of things in ways to confront it, but obviously we don't know the full extent of what we can do to prevent child abuse. And I can't think of a better group of people to come together and think about these issues in a substantive way. We're honored both because of the quality of this panel, but also I have to say because this is also part of a joint project at the University of Pennsylvania Law School with the School of Social Work, as well as the Children's Hospital and the Nursing School, the Field Center, which is devoted to these issues. And Rich Gellis, who is the dean of the Field Center, who I know is going to appear later on, wished he could be here, but unfortunately he's holding his Board of Overseers meeting today, and therefore asked me to come and sort of sub for him. I just want to give an incredible support for the Field Center because it really is at the center of looking at these issues across fields and across disciplines. It's good to have Dr. Christian here, who is one of the co-directors of the Field Center, as well as Deborah Wolf, who is the executive director of the Field Center, and one of our own faculty members who is about to be here, Kara Fink, who we've just appointed to work in these issues. So again, I'm really honored and delighted that you could use our facilities. I encourage you during the day, if you want to take a walk around this glorious new building. Risk management allows people to walk around now. We're still in a punch list, so you may see a hammer falling in one direction or whatever, but just duck well in any event. So, Mr. Chairman, thank you all and welcome to everybody and have a wonderful day. Thank you.
Thank you very much. And I will ask that I guess for the record, that the panel introduce yourselves, starting Doctor, if you'll be so kind, and we'll just go right down.
Hi, my name is Dr. Berger. I'm from Children's Hospital of Pittsburgh.
Good morning. My name is Gary Ipach. I'm the director at Glen Mills Schools.
Good morning. My name is Arthur Grimm, senior judge from Berks County.
Good morning. I'm Jason Kudalakis. I'm an attorney from Carlisle, Pennsylvania.
Good morning. I'm Cindy Christian. Welcome to the University of Pennsylvania. I am a pediatrician at Children's Hospital of Philadelphia, co-director of the Field Center, and the medical director for the Department of Human Services.
Good morning. My name is Jackie Bernard, and I'm a prosecutor from Blair County, Pennsylvania.
I'm Dave Heckler. I'm district attorney of Bucks County.
Good morning. I'm Bev Macrath. I'm the Deputy Secretary for the Office of Children, Youth, and Families.
Delilah Rumberg, Pennsylvania Coalition Against Rape, National Sexual Violence Resource Center.
Hello, my name is Carol Pachado, and I'm employee of the Department of Human Services. Thank you.
All right, without, pardon me, without further ado, our first presenters this morning are Doctors McColgan and Scribano. Both, well, you can tell us a little bit about your experience, but I know that you both practice in the area in which you unfortunately have regular contact with abused children. Doctor.
Good morning, Chairman Heckler and members of the task force. I'm Maria McColgan. I'm the director of the Child Protection Program at St. Christopher's Hospital for Children and associate professor of pediatrics at Drexel University College of Medicine. I'm honored to be here today among so many of my esteemed colleagues and humbled by the opportunity to present to you today. Since completing my pediatric residency at St. Christopher's Hospital for Children, I've practiced child abuse pediatrics and, along with several of my colleagues, became one of the first board-certified child abuse pediatricians in 2009 in the United States. In addition to my clinical responsibilities at St. Christopher's Hospital, I'm also the pediatric advisor for Prevent Child Abuse Pennsylvania. Prevent Child Abuse Pennsylvania is an organization that's dedicated to the primary prevention of child abuse and neglect and sits under the umbrella of the Pennsylvania chapter of the American Academy of Pediatrics. In addition to representing St. Christopher's Hospital, I'm very proud to represent both of those organizations here today. I'm hopeful that my testimony will bear witness to the realities of how often and harshly some of this state's children are exposed to child abuse. Abuse we'd like to believe doesn't exist, but as my testimony will confirm, is quite real and consequential for the child and society overall. Over the last 2 years, I've been connected with an interdisciplinary coalition known as the Protect Our Children Coalition. POC has provided a forum for professionals and advocates like myself who work in the trenches of child abuse and have solid insight on how things are in practice on the front lines, but who are often unconnected to the usual policy generating tables. Through POC, we've been able to share information, expertise, and our frustrations, realizing there was potential in our collective advocacy. So last year, I joined many doctors, public and private child welfare workers, legal experts, social workers, children's advocacy center and victim service leaders, disability rights advocates, law enforcement, researchers, drug and alcohol and mental health clinicians in a call for a state-level task force on child protection. We were certain that Pennsylvania's children and families could benefit from a research-driven and grassroots-informed analysis about how Pennsylvania is doing, including in preventing child abuse and implementing core front-end child protection policies, including defining, reporting, investigating, and assuring a pathway to services for the child and family. So I am here first today to affirm that this task force and each of us can elevate the voice of the very vulnerable children whose voices are muffled, if not silenced, in the halls of power. Together, we must dedicate ourselves, individually and collectively, to chart a new course for Pennsylvania's most vulnerable children and families and recognize our children as our most valuable resource. My testimony today is framed from the perspective of a practicing child abuse pediatrician for almost 10 years. In that time frame, I've identified and treated thousands of injuries, physical abuse, sexual abuse, neglect, resulting from some of the most horrific treatment of children that can be imagined. My perspective is from the medical treatment of the child, and I have too often witnessed how the tragedy is compounded by inadequate state laws that too often exacerbate the vulnerability of the child and leave the child and family unconnected to services and complicate the decision-making of local child welfare workers. A few weeks ago, I was presenting at a conference in Bucks County. A children and youth case worker told me about a child that she was still losing sleep over. The child had had a bruise on his ear, an almost diagnostic sign of an inflicted injury, as it's quite unusual to get an accidental bruise on the side of your head. She felt that the injury was due to an abusive act and wanted to indicate the case as physical abuse. Ultimately, she and her supervisors, however, decided that she was unable to indicate the case as child abuse because the bruise did not meet the threshold set by Pennsylvania statute as a severe injury, nor did the injury cause sufficient pain or impairment. Regrettably, we have seen countless cases like this. The child who has marks, bruises, or welts from being hit, spanked, whooped, or otherwise physically disciplined. But state law establishes that the child's injuries were not severe enough to be determined to be child abuse. And consider the 2.5-year-old child who presented to our hospital last year with an extraordinarily high sodium level. After an exhaustive workup for medical causes, we diagnosed her with salt poisoning and physical abuse. Based on the medical diagnosis of child abuse, the caseworker indicated the case and named the mother as the perpetrator of the child abuse, and the child was placed in foster care. A court, however, overturned the finding of child abuse, saying that the investigation had not proven that it was the mother who was directly responsible for the poisoning. In other words, the court felt that the perpetrator was undetermined. Therefore, the child was returned home with her mother. Several months later, the child returned to St. Christaldron with multiple injuries, including a severe burn to her hand that hadn't been treated for weeks, severe malnutrition, bruises and scars all over her body, including bruises to both sides of her ears, and a healing laceration behind her ear that we subsequently learned from her sister that her mother had almost pulled her ear off. Consider as well the twins who had subdural hemorrhages, retinal hemorrhages, and fractures, which led to a very clear medical diagnosis of child physical abuse and inflicted traumatic brain injury. The family members who were indicated appealed and won because there were 5 different caretakers in the time frame when the injuries might have occurred. Again, rendering the case unfounded because the perpetrator was unknown. Building the foundation of child protection based on adult-driven versus child-centered policies is a significant shortcoming in Pennsylvania. I can recount too many cases where there was a clear medical diagnosis that the child was abused, but the child welfare investigation, driven by state law and practices, determined that abuse did not occur. In such cases, the child's injuries that were medically diagnosed as child abuse remain uncounted in our official state statistics. Consider, too, that so often in these unfounded cases, despite medical diagnosis, critical pieces of information to better protect this child going forward will not exist. Where pieces of information might be retained, it likely won't be shared with the next doctor or child welfare investigator. Where a perpetrator is undetermined but abuse has occurred, or in other cases where the report was unfounded, the records must be destroyed within a certain period of time. Also, Pennsylvania collects and retains no data about a child who may have received general protective services, services offered since the 1990s to address circumstances where safety concerns exist, but which were deemed non-abuse cases. So often, the child of a prior unfounded report or the recipient of a GPS presents again at a later date in an emergency department or with a new pediatrician because so often these children do not have a medical home. The treating physicians and the child welfare workers seeing the child this time often will not have all the facts and are left with the impression that this is the first time the child has experienced injuries that could have been abuse-related. The final case I'll present here today is certainly far from the last example of cases that I have been involved with in where Pennsylvania's definition of child abuse was confusing and not sufficiently protective of the child. I recently cared for a 7-week-old infant who was brought to the emergency department because he wasn't moving his arm. He was noted to have a fracture of the humerus, which is the upper bone in the arm, and on further workup, we found other fractures, a bruise, and a healing laceration in his mouth. The medical diagnosis was most certainly inflicted injury and physical abuse. However, in family court, the defense attorney argued that this case, although likely an inflicted injury, does not rise to the level of our state's definition of abuse, because it didn't lead to an impairment of the child. He argued, how could the child be impaired? Because he's only 7 weeks old and doesn't even hold a bottle on his own. Therefore, this child could not be considered impaired as a result of his injury. Remarkably, the judge agreed and ruled that this was not child abuse and ordered that the child be returned home. While we all appreciate and want to find the appropriate balance in safeguarding the rights of parents with protecting children, this case and the high bar to determine a child has been abused illustrates, to me at least, that we've not yet struck the right balance. Even in this case of a very clear medical diagnosis of abuse, our state's law raised enough confusion to rule against the legal definition of child abuse. Another element of our state's definition of child abuse relates to the inclusion of severe pain. As a physician, I am of course a mandated reporter of abuse, and so often find myself making a call to Childline to report child abuse. During the course of my report and the subsequent investigation, I will be repeatedly asked, did the child suffer severe pain? This question is fraught with so many problems. As you know, pain is very subjective, meaning that an injury that one person might rate as a very severe 10 out of 10 pain, another person might rate as a moderate 6 or 7 out of 10 pain. With children, this becomes even more difficult. I can't determine with any certainty the level of pain that a 7-week-old, a 13-month-old, or even an older child may be experiencing due to their injury. For example, is a child who has bruises on her buttocks, who can't sit comfortably, experiencing severe pain? Or how about the infant with a femur fracture? When no one's touching that child or moving that child, they may be able to sleep, but does that mean they're in any less pain? Nor does it mean they haven't suffered an abusive injury. Pennsylvania and much of our country turned its attention to reporting child abuse in the wake of the Jerry Sandusky and Penn State scandal. And we know we will fail our children again if we ignore that reporting is impacted by how we define abuse and what happens after a report of concern for abuse has been filed. Pennsylvania's definition, particularly the provisions related to severe pain, impacts the likelihood of a medical provider to report subsequent cases of suspected abuse and neglect to Childline. We're in the process of piloting a new program at St. Christopher's Hospital for Children called the Family Safe Zone, the goal of which is to change attitudes toward corporal punishment and increase bystander willingness to intervene on behalf of the child. During one of the meetings to organize this program, one of our social workers noted her responsibility to report suspected child abuse. And with that, she voiced her frustrations in calling in reports to Childline, stating, their mindset is so toward the severe that you have to fight and beg, even as a medical provider, to get them to accept the case. I can go on for hours with similar cases in which Pennsylvania's state law created such difficult restrictions that an injury must cause severe injury or impairment of the child to be deemed a case of abuse or neglect. And I want to assure you this is not a Philadelphia-specific challenge, because all of the other counties are operating under the same limiting law, and I have consulted on similar types of cases that I illustrated today from across the Commonwealth, and in fact, most of the cases I presented today were not from Philadelphia. Linked to the definition and influencing our adult versus child approach to child protection is the role and nature of the state's child abuse registry. Persons named as perpetrators of child abuse will have their status known when they apply to work or volunteer with children. And of course, this registry serves a critical role as it provides potential employers or community-based volunteer organizations with information to better protect our children. It is, however, time to evaluate the role of the registry in terms of who is on the registry, for how long do they remain on the registry, the mechanics of its operation, and in particular, the appeal process for having one's name removed. In a Commonwealth that has set the bar very high as to what injuries can be inflicted on a child and not be deemed abuse, I've been repeatedly cautioned to set my expectations for change low. I've been told that it's too controversial to bring up any discussion of corporal punishment, and I'm reminded often that Pennsylvania is a more conservative state, and that we are remiss to intervene in a parent or caregiver's ability and right to discipline their child with physical interventions. Well, with all due respect, I am a conservative, and I believe that it's time not only to begin this discussion, but it's long overdue. We must talk about what is appropriate and acceptable discipline and what is unreasonable punishment. In a talk by Dr. Sandy Bloom of Drexel University School of Public Health, I saw and remained influenced and inspired by a slide that she put up. And in it, it stated, hitting an adult equals assault. Hitting an animal equals cruelty. But hitting a child equals discipline? I'm not considering that we begin a debate on the appropriateness of a simple swat of the hand to a toddler who's reaching for a hot stove, or pulling the arm of a child who's running out into the street. However, I am suggesting that we begin to discuss moderate to severe forms of physical punishment. We need to ask the tough questions, such as, when is it ever acceptable to hit a child? Should it be legal to hit an infant or toddler who don't yet understand that the hitting is linked to the action that they just did and that you want to change? When is it ever acceptable to spank a child, and for what reason? And most importantly, if you are going to spank a child, is it ever acceptable to use an implement such as a broom, an extension cord, or even a belt? To find the answers, we have to look carefully at the data, as we now have a wealth of medical and psychological studies to show the effects of physical punishment. Several studies looked at the frequency of hitting children. For example, 17% of mothers reported spanking an infant under 13 months old within the past week of a study. 26% of mothers reported hitting their 3-year-old children greater than 2 times in the past month. 35% of parents have spanked their 4- and 5-year-old children within the past week, and 80% of all children were hit by the time they reached 5th grade. As a result of the ACE studies, the Adverse Childhood Experiences Study, one of the largest studies of its kind, and that has subsequently been replicated, we now know that adverse childhood experiences, such as physical abuse, neglect, sexual abuse, exposure to domestic violence, can lead to a wide range of long-term health consequences, risk-taking behaviors, psychological problems, etc. And we also now know that physical punishment, including spanking, can lead to toxic stress that can lead to actual detrimental changes in the structure of the developing brain. I apologize, I had slides, but we were unable to project them. But it showed that in one study, subjects who were victims of physical punishment were actually noted to have significant reductions in the gray matter of the brain. And in various other studies, children who experience physical punishment are at higher risk for behavioral problems and delinquent behaviors, low self-esteem, depression, substance abuse, poor quality of relationships with parents, physical abuse of one's own spouse and children as an adult. Spanking is also shown to lead to increased risk of physical aggression, antisocial behaviors, conduct problems, and internalizing behaviors among children. Therefore, the American Academy of Pediatrics strongly opposes hitting a child for any reason. As a result of what these studies have taught me, and from my experience of treating children who have been injured by a disciplining parent, I encourage all parents that I see to abandon all forms of hitting and encourage them to use other forms of more positive discipline. Positive parenting is proven to be more effective and lead to healthier outcomes in the long run. As a doctor and as a parent of young children myself, I invite the discussion with parents and work with them. And for those who insist that they need to use hitting to punish their child, I ask them that they consider the alternatives. But if they will not abandon their use of physical discipline, I recommend that they only hit with their open hand so that they too can feel the pain that they are inflicting when they are hitting their child. There are now 29 countries that prohibit corporal punishment of children, even in the home. In the United States, there are no federal or state laws prohibiting physical punishment in the home, and in fact, only 28 states and the District of Columbia prohibit physical punishment in public schools. And the construction workers in the back wanted to put some emphasis on those points. Legislation on the use of physical punishment in other settings caring for children varies from state to state, as you know. We should look at the effects of these prohibitions in other countries and in other states to help guide us as we decide what the right legislation is for Pennsylvania. As a lifelong Pennsylvanian, I'm disheartened by the fact that Pennsylvania was the last state in the country to become compliant with the Child Abuse Prevention and Treatment Act. It took until 2006 to complete this goal. I would love to someday be able to say that I live in a state that is a leader in child protection, that I live in a state where children are not only protected, but revered and held on a pedestal and recognized as our most valuable and cherished resource. I want to live in a state where it doesn't matter what your race or color is, it doesn't matter what your religion or political party, but that it is never okay to injure a child. I want to live in a state that values prevention, not only because it's economically beneficial, but because it's the right thing to do, and the best chance for ensuring that all children are raised in nurturing environments that allow them to live it to their potential. At midnight last night, I realized I was about 7 pages into this speech, and I hadn't even touched on sexual abuse, neglect, or school abuse. But the themes are the same. Why should the threshold be severe neglect? Why do we not routinely believe a child who discloses that they were physically or sexually abused? Why isn't the abuse of a child in a school setting considered a case of child abuse and investigated in a similar manner? It's incredibly frustrating as a medical provider to repeatedly refer cases to Childline, only to find out that they will not be investigated as a Child Protective Services report and are sometimes not even accepted as a General Protective Services report. I also want to take a very quick moment to focus on prevention. Of course, the very wise Benjamin Franklin said, "An ounce of prevention is worth a pound of cure." Well, with child abuse and neglect, an ounce of prevention may be worth something more like $100 billion in cure. Recent estimates of direct and indirect costs of child maltreatment range between $104 and $124 billion in indirect and direct costs in the United States. We need to shift our focus from intervening after the damage has been done to prevention before it occurs. We must send a message to all Pennsylvanians that prevention is indeed possible and that each and every one of us has a significant role to play. Honored members of the task force, thank you again for the opportunity to hear my testimony today. I hope that as you consider the complex issues of child abuse and neglect, you will remember some of the children that I presented here today and know that the work you're doing will help to improve their future and all of ours. Thank you.
Thank you, Doctor. I assume you can remain for the duration of the panel so that we'll defer questions until we've heard from your colleague. All right, Dr. Scribano.
Good morning, Mr. Chairman and this distinguished committee. Thank you for the opportunity to speak to you today on a critically important issue to children in our state. My name is Phil Scribano, and I'm the medical director of Safe Place, which is the Center for Child Protection and Health at the Children's Hospital of Philadelphia, and I'm professor of pediatrics here at the Perelman School of Medicine at the University of Pennsylvania. I am also board certified in pediatrics and am in the distinguished mix of about 200 board certified child abuse pediatric subspecialists in the United States. I've spent about 15 years of my pediatrics career focusing on this issue, and in specific, the medical and psychological aspects of children who have been abused or neglected. I come to you this morning with the vantage point of having joined my esteemed colleagues in this field in Pennsylvania only about 10 months ago, after having practiced in Connecticut and in Ohio for the last 9 years. In my clinical practice, I've evaluated thousands of children suspected of having been abused or neglected with a broad scope of clinical practice. My work here in Philadelphia, as well as my efforts in Connecticut and Ohio, included extensive involvement with multidisciplinary teams, including Child Protective Services, law enforcement, and mental health disciplines. In fact, in my work in Ohio, we had direct involvement with over 18 CPS caseworkers and supervisors that were co-located with my medical team in a child advocacy center model. in addition to the many other caseworkers and law enforcement agents in the state. Additionally, very similar to what Pennsylvania is doing right now, in 2005, I was appointed to a committee to look at child welfare reform in Ohio, and looked at that in the context of determining whether or not we were doing the best that we could do in that state. So I come to you this morning with a brief experience in the unique issues we face here in Pennsylvania, but with a broader experience in understanding the typical challenges in child abuse, neglect, and reporting, and the need for ongoing efforts to improve the quality of our child protection systems. In my current role at CHOP, I'm responsible for the oversight of the clinical services of maltreated children and for our educational training for the next generation of pediatricians pursuing this honored specialty. The challenges in protecting children from the trauma of abuse and neglect are highly complex and begin with a clear and consistent approach to the reports that are submitted by professionals and the public when abuse and neglect are suspected. Clearly defined laws translate to clearly defined child welfare decisions to ensure that children are protected from the child abuse and neglect risks they may have endured. Clearly defined laws also translate into a more precise understanding of the burden of child maltreatment in our state and the opportunity to target prevention in areas we identify as having higher risk and the greatest gain from our targeted efforts. I come to you today with the experience and skills of a pediatrician, educator, and researcher, and represent my colleagues at the Children's Hospital of Philadelphia within Safe Place and the Policy Lab. We applaud the efforts that you're making to improve the ability of Pennsylvania to more effectively protect children. I'd like to share with you my perspective on some of the issues that I grapple with as a child abuse pediatrician. These issues have a direct impact on the front lines of care and offer an opportunity to advocate for future policy decisions which enhance and improve our ability to protect children. The first aspect is just our efforts to improve consistency in the way CPS responds to suspected reports. Pediatricians and other health professionals in general have a limited trust to the system when it comes to their mandated duty to report suspected abuse or neglect. This has been eloquently evaluated in a formal fashion in a national research study by a colleague in Chicago, Dr. Flaherty, with her results demonstrating a significant proportion of pediatrics physicians, over 1/4, who did not report suspected child abuse, despite having the opinion that the child was a likely victim of abuse. This attitude is often stimulated by the perceived inconsistencies of Child Protective Service decision-making observed by practicing physicians. Physicians report that they feel that the response of an investigating agency has been unpredictable and often frustrating as they attempt to do the right thing by making a report, however, feel that they may not have adequately served their pediatric patient and family. First, I will state that the potential inconsistencies in decision-making are somewhat universal across states and exemplifies the incredible challenges of our work. In my brief experience here in Pennsylvania, I've observed this inconsistency, and as a child abuse pediatrician, I've felt an even greater burden to pursue and follow up with Child Protective Service workers and investigators after I've completed an evaluation. Due to the potential variability in response across counties, and even within the same county and even within the same unit of a county, an unfounded determination of child abuse may not be consistent with the medical opinion that the injuries a child sustained are the result of abuse. While the Child Protective Service system and healthcare system perspectives on the determination of child maltreatment may not always be concordant, there are cases in which a statutory language limits greater agreement between these two critical entities. I recognize this reality in the system and attempt to work with these nuances of investigation. However, many of our general pediatrics colleagues may find the perceived ambiguity of decision-making less tolerable and develop an avoidance behavior to this important role of reporting suspected child maltreatment. In moving forward, if there could be an emphasis on greater standardization of investigations and disposition-making processes across the state and within counties based upon the existing statutes and rules, we may find improved reporting rates and less skepticism toward child protection by mandated reporters. With that said, if there are foundational requirements in defining child maltreatment which are problematic and subject to wide interpretation and/or unfairly constrains CPS in making the determination of child maltreatment, efforts to remedy the problem would seem to benefit best interests of the child, family, and our Commonwealth. The second issue I want to address is just the challenges of the statute conditions and specifically addressing the identified perpetrator and intent. The first problem is the issue of the identified perpetrator. When evaluating injuries to determine whether an injury is the result of a non-accidental cause, the primary objective of our evaluation is to recognize whether the history provided is plausible to explain the injuries identified. The medical decision-making is based upon our knowledge of the mechanism of injury, child developmental abilities, healing characteristics of injuries, possible medical conditions that may present with similar signs or symptoms, and potential inconsistencies thereof. For example, a 6-month-old infant presented to the hospital with a sudden deterioration in functioning with coma was identified to have brain injury as demonstrated by subdural hemorrhages on a CAT scan of his head. Retinal hemorrhages were observed in his eyes, and rib fractures were noted on the initial chest film. The treating physician was provided with the history of a fall from the bed as an explanation for this child's presentation. The implausibility of this explanation, given the factors described, prompted the treating physician to have suspicion of child abuse and reported to Child Protective Services. Now, during the course of the investigation, however, it was unclear which adult was the perpetrator, since there were multiple caregivers who were with the infant within the few hours prior to his deterioration. Could it be the uncle who was playing video games in the living room? Could it be the mother who stated she changed the child's diaper and placed him in a crib before leaving the apartment to run some errands? Could it be the father who stated he checked in on the infant after taking a break playing a video game with his brother and reported that the infant seemed okay? During the course of the investigation, one may be able to narrow suspects. However, in many cases of child abuse, and in specific in the more severe cases such as abusive head trauma, there may not be an identified perpetrator, despite significant investigative efforts. I know that Dr. Berger has previously provided testimony regarding the research that we conducted in which we evaluated children with unequivocal abusive head trauma and demonstrated a significant increased rate of abuse during the recession compared to the preceding years. What I wanted to also bring to your attention was part of our research, we also looked at the perpetrators of these cases, and what we found that despite cases being medically determined to being unequivocal as being abusive, over 25% had an unidentified or undetermined perpetrator in that study. As a result, for our patients in Pennsylvania, our current statutes, which require that the perpetrator be known as a requirement to enter the case on the state child abuse registry, we would systematically underestimate many cases of child abuse. It's important to note that the bar for our study was very high in counting a case as abuse. There were many other cases that we reviewed in this study where there was a good likelihood that the injuries were due to abuse. However, we excluded those cases which had less stringent clinical evidence to be counted as definitely abusive for this research. Now, if you extrapolate the possibility of not identifying a perpetrator to other types of child abuse, it would seem plausible that we are significantly undercounting the number of cases of child abuse in our state, and therefore underestimating the true burden of the problem. The implications of our under-ascertainment of abused children include an inadequate size of our workforce and other resources to provide child protection services, and this extends to an overburdening of other vital systems such as health, welfare, and other support services to children and families. Accurate counting of child victims of abuse and neglect provides greater understanding of the issue and provides more accurate information to make the best public policy and public health decisions for these children. I want to now address the issue of the intent in our statutes. If we continue to analyze this case, we'll note that while the family in this case was struggling economically and was the recipient of food stamps and medical assistance to care for their infant, there were no clear indications that there was an intent to harm. In fact, it is the general consensus within the medical and child protective services communities that for many of the cases of child abuse, especially the more severe forms, as I've demonstrated in this case, the injury is most likely caused by a caregiver with poor coping skills to manage a crying infant in need of attention, compounded by a low frustration tolerance, which sets the stage for an injury inflicted on a child. As such, many cases of child abuse may not fulfill the criteria of intent to be categorized as a non-accidental injury. Given the subjectivity of this criterion and the need for further law enforcement investigation to assist in determining intent, these cases may not be counted in the child abuse registry, resulting in an underestimate of the rate of abusive injuries in Pennsylvania. Now, when I think of this particular challenge for us, I've really grown to appreciate a legal construct in defining child maltreatment which is not dependent upon this determination, but rather is focused on the incident and subsequent needs of the child. Several states in the United States have adopted a legal framework referred to as the Child in Need of Protective Services or Child in Need of Services, CHIPS or CHINS model. Exploration of this framework may be beneficial to this committee in consideration of any statutory changes to the current definition of and response to child abuse and neglect in Pennsylvania. I particularly appreciate this framework as it ensures that our child protection laws have as their focus the perspective and needs of the child. Specifically, this approach focuses on child protection and leaves the determination of a criminal act to law enforcement without having the law enforcement legal burden to determine if a crime was committed shortchange the need for mandated child protection services. For example, if an injury is determined to be abusive in nature from medical opinion, child protective services, or law enforcement investigations, regardless of being able to determine who the perpetrator is in an abusive injury or the intent of the perpetrator, the case would be founded as an abusive injury and appropriate protection plans would be established, and the case would be counted as such in our state registry. It's important to note that this approach does not preclude engagement of law enforcement agencies in appropriate cases to pursue criminal charges. In fact, it encourages collaboration where appropriate, but makes a clear distinction between the two mandates: child protection to determine abuse and neglect to ensure protection from further harm, and law enforcement to hold perpetrators accountable for crimes committed against children. With this statutory transformation, it may be daunting to consider what that might entail. There may be some elements of this approach which can be utilized in the current efforts that you're undertaking to evaluate Pennsylvania's definitional criteria for child maltreatment. The last thing I want to address are the efforts that I want to consider or recommend in that deal with adequately measuring and monitoring repeat reports on a child. An important metric in determining quality of a child protective services system is the recidivism rate of children previously in the system due to child maltreatment concerns. Unique to Pennsylvania and what makes our state an outlier in national statistics, in part relates to our statutory distinction between Child Protective Services, CPS, and General Protective Services, GPS. In the most recent national statistics in 2010 from the U.S. Department of Health and Human Services, the NCANS report, Pennsylvania's response, which was the screened in for investigation, was 8.0 per 1,000 children compared to the national mean of 40 per 1,000 children. The substantiation rate was 1.3 per 1,000 children compared to a national mean of 9.2 per 1,000 children. Given the degree to which these statistics demonstrate the unique structure of GPS and CPS, and the fact that Pennsylvania's alternative response system is the GPS, at a statewide level, we are unable to track children identified within GPS for the purposes of determining re-reports to the Child Protective Service system. Ensuring that county data are included for state statistics on this population of children being evaluated for concerns of child maltreatment and/or the need for Child Protective Services seems a critical goal for us to address so that this data gap is not hampering our ability to recognize all of the burden of child maltreatment in our state. Furthermore, if a child is reported within CPS, if a prior report or reports, as often is the case, was made through GPS, this CPS report is not considered a re-report. This compartmentalization of child protection, based upon the compartmentalization of our statutory language, significantly limits our ability to measure quality of our overall Child Protective Services system. And it also hampers our ability to strategically position prevention interventions to reduce the risk of re-reports to GPS and/or CPS. Finally, the work of the Policy Lab at CHOP by Drs. Joanne Wood and Dave Rubin also highlights the limited perspective of these data when discussing the burden of child maltreatment in our state. Despite the decreasing and relatively low incidence rates of child maltreatment from NCANS data, there was a consistent increase in the hospitalization rates for physical abuse in Pennsylvania. While this hospitalization population of abused children is just the tip of the iceberg, it alludes to the challenges in determining the most effective policies if we are relying upon data sources which may not provide the entire story. Our CPS and GPS activities need to be coordinated in such a fashion as to provide the full picture of child protection. In my current research focusing on the reduction of intimate partner violence in the context of home nurse visits, having a thorough understanding of the risk of injury was a critical first step for us in being able to develop and implement an intervention to reduce further trauma in that population. And I think in the same way, for us to effectively protect children from all types of maltreatment, a thorough understanding of those children who had GPS investigations will inform strategies that optimize resources and reduce the risks of child maltreatment and subsequent reinvestigation by our Child Protective Services. In conclusion, the stakes are too high for the unintended consequences of statutory language to diminish the fact that a child has been maltreated and is recognized and counted as a child victim of maltreatment with the appropriate services provided as a result of that designation. The explosion of research linking these traumatic experiences of childhood to a lifetime disparity of health and well-being creates an even greater urgency for us to work together to address these challenges. I would recommend that we, one, improve the consistency in the investigation of reports of child abuse and neglect, two, to provide a remedy to current Pennsylvania statutes requiring the determination of the identification and intent of the perpetrator, and three, provide a process to effectively measure maltreatment investigated through GPS to accurately assess re-reports of child maltreatment as an indicator of Child Protective Service system quality. These are some key initiatives that I think would make a significant difference in our state in improving our collective abilities to protect children and support families. Thank you, committee, for the opportunity to testify before you on this important matter. And I look forward to continuing to work with you to ensure that we protect some of our most vulnerable children. Thank you.
Thank you, Doctor. Questions from, for either of our presenters? Maybe again, we'll start down to the left. Anyone?
So thank you both. I think you raised a lot of the really important issues that we've heard, I think, a few times, but I think you articulated them really nicely. One thing that Maria, I know, was talking about was the issue of mandated reporting and who's a mandated reporter and how do we get people to mandate report. One of the things that I've been concerned about a long time is trying to improve mandated reporting without first improving, as Phil said, the consistency of the response, because as you alluded to, Emily Flaherty's research shows that you have if a physician has multiple negative interactions with CPS, where I always compare it to you have an obligation as a mandated reporter on one hand and your Hippocratic oath on the other. And if you truly believe that by reporting this child, the family will be worse off or you can't predict, then your Hippocratic oath tells you you should not be reporting. And I think that's a constant battle for physicians because of this extreme inconsistency. And so I have a little bit of concern about any change in who should mandate report, in any change in how much we educate mandated reporters until we fix the other end of the system. What is your feeling about that?
I actually think they should come hand in hand. I don't think we should wait to fix one until we fix the other. I've been told by many people that if we increase the number of mandated reporters, we're going to increase the numbers and overwhelm the system. If that's what it takes to bring attention to the fact that these children are being injured, abused, neglected, etc., then maybe that's what has to happen. I'm not sure. I don't know the answer to that question. I do think educating mandated reporters is a very important issue. I don't understand any mandate to do something that you don't provide a mandate to get training, to understand what your responsibility is. I was a teacher prior to this. I went to medical school. I did pediatric residency, and it wasn't until working with all of you in child abuse pediatrics that I learned learned the true meaning of my responsibility of mandated reporters, and I've done a lot to educate folks at my hospital. I don't know that there's any other mandate out there that is similar, where you have a mandate but you don't explain to people their responsibility. So I think educating mandated reporters is the way to go. I am not an advocate of mandating all Pennsylvanians to be mandated reporters because I don't think, first of all, I don't know how you would enforce that. And I think there has to be some judgment and we have to leave some things to ethics, morality, and personal judgment. So I don't know that it's the right thing to mandate all Pennsylvanians to report. I do think we do need to fix the other end, but I'm afraid that if we don't do the training for mandated reporters until all of that gets fixed, A, it might not ever happen, and B, you might have some very severe injuries happen as a result of being able to choose when you report. And I just recently had a horrendous case where the physician, for some reason, was hesitant to report. And a subsequent terrible injury happened to that child a couple months later because it wasn't reported, because all of the reasons that a physician doesn't report. Oh, I'm not sure if it really was an abusive injury or not. I, don't want to upset this family. It's a really nice family. The report to this family who's already stressed and has a very young child may actually cause more damage than good. I don't think we should be making that determination. I think we have an obligation to report, and it's up to all of us to make sure that other end happens correctly.
I equate the question to what we are seeing in the United States regarding healthcare. And we are embarking upon the next horizon, and as a physician, I hold great optimism that we will get it right for our children in regards to healthcare reform, regardless of what may happen with our Supreme Court decisions and the like. I think in the same way, we've got to recognize that child welfare reform must happen. And the way in which we do that is by looking at the reality that we will not have increased resources, likely, to do a better job with what we have before us. And I think that's the daunting task of healthcare reform. I think that's the daunting task for child welfare reform. And so I think before we embark upon any expansion in terms of statutory requirements, that's why I brought up the issue of if we could just do what we are doing and create some consistency, I think we might have greater synergy within the other systems of care, and specifically within health. It is the most unrewarding discussion to have with colleagues in our field, in medicine, when we talk about child protection. And we play cheerleaders because we embrace the importance of working with child protection, because that's the core for helping the population that we serve. But many of our colleagues have a very different take. If we don't grapple with that reality, I don't think we're going to really get any momentum in improving what we're doing with regard to mandated reporter at the very base level. So that was sort of the premise behind my statement earlier.
First, I was educated quite a bit, and I appreciate the information coming from dealing with youth who are much older, 17, 18-year-old delinquent, adjudicated delinquents. But one thing that I believe you said, Doctor, about taking care of the most vulnerable, and it kind of amazes me that, you know, if you have, I hear you say, if you have evidence in your professional opinion that abuse has taken place, sometimes it's difficult for whatever reasons to have it assigned and investigated. And as we move forward in making recommendations, you know, I would like to learn more about the services, CHIPS and CHENS, and some of the things that Ohio's done. But as we move forward, resources certainly would be an issue in question in these times, how much additional resources, and the redirection of our energies that we spend is probably more of a reality of let's direct energies where the most vulnerable, and certainly when I hear 11 weeks old and 2 years old, and it's an interesting challenge, but thank you for your comments, and any information about the Ohio efforts would be very helpful.
Sure. The CHIPS legislation recommendation was born out from two main evaluative processes. One was at the national level, and we included and hired Howard Davidson, from the American Bar Association, to give us a national perspective on what states were doing around child welfare, and gave us a really nice snapshot and gave us an opportunity to look at a more progressive, potential progressive approach to child welfare in our state. We also had a ground level evaluation through the National Center on Adoption and Law Policy within Columbus, and they did survey research and spent a fair amount of time with all of our county agencies, from executive directors, supervisors, down to the caseworkers, and extended out to all the other disciplines. And that combination of data concluded with two main recommendations. One, which was because of the convolution of layering of statutes upon statutes that had both criminal and child protective implications, there was so many inconsistencies that there was an impetus for us to consider a drastic or more significant shift in our statutes. The second recommendation was alternative response. We did not have an AR pathway within our system. That process has taken off. It started with 10 counties of 88 as the first pilot that had a formative evaluation that continued to another 10 pilots. They're up to about 62 counties, I believe. I just spoke to the person overseeing all of that, this past week in preparation for this hearing, and it continues to make good headway. The difference is they continue to evaluate the outcomes. They continue to look at the effectiveness of that change in child protection to ensure that we're not creating unintended consequences by virtue of such a change in child protection. The CHIPS legislation, the bill was drafted in 2010 and was introduced, a bipartisan sponsorship bill, at the end of 2010. And with election years and term limits and the like, it stalled, and they are now re-engaging with a whole group of legislators and trying to sort through their next steps. Again, there is momentum in that state, and I live as an idealist. I underlie that as a pragmatist, but I think the two can go hand in hand, and I do believe that from my experience in the 5 years serving in that committee, that they will find that to come to fruition. The challenge, however, is financing it, because you're talking about not so much a cost that is related to incurring on the basis of added resource. And in fact, all of the data would argue that there's a more efficient way of providing care, but it's the training and the front load cost of training a whole system in a state that has them being cautious during these economic realities in these days. So I don't know where it's going to go, but I think that there are some lessons that might be applicable to your work that is why I was bringing that up.
Thank you.
In regard to resources, I know, of course, resources are tight in this economy, and we have to think about again, the long-term effects and the costs of child abuse and neglect. And I mentioned the Adverse Childhood Experiences study. We know that child abuse and neglect lead to substance abuse, heart problems, obesity, I said substance abuse, promiscuity, it's a host of health and psychological problems and risk-taking behaviors. We know that, for example, Delilah can correct me with the statistics, I can't remember exactly, but in one study of an inpatient substance abuse facility of women, 66 or 75%, either way, an inordinate number, were victims of sexual abuse as a child. If we were able to prevent that, could we have then prevented the costs of the inpatient admissions, all of the other loss of productivity, et cetera? And so we have to think about it as an investment rather than just utilization of resources. I talked about the $104 to $124 billion a year. Imagine what Pennsylvania's share of that is. So the costs are very high of not doing something about it up front.
You know, to just briefly echo what you've said, in my work, which is juvenile delinquency, the statistics that we have indicate self-reporting statistics from the kids that come into our system, that upwards of 90% of those kids have suffered from abuse, either directly perpetrated upon them or witnessed domestic abuse in the family. So it's clearly a huge issue. One of the other things that we have found from the information that comes from these kids on intake is that a lot of the abuse situations occur when the abuser, the perpetrator, is either using drugs or alcohol, which is not to suggest for a moment that the abuse is dependent upon that, but it seems to be often a precipitating factor that leads a person who is probably predisposed to abuse to do it. Has that been your experience as well in your practice?
Yes. Going back to your statement about the 90% of kids who've been abused, I just want to touch on that, in juvenile delinquency court have been abused. I like to think sort of very simply, if you hit a child, to discipline them, you hit a child because Susie takes Johnny's toy. Well, when Susie goes to school, what's Susie going to do when the little girl next to her takes her toy? We're teaching them that hitting is okay, and so we need to think about that. But coming back to your question of substance abuse, it becomes a vicious cycle. no doubt about it. You know, you were abused and neglected, you wind up using drugs, so you then, then are abusing and neglecting your own children, et cetera, et cetera. So it becomes a vicious cycle. And one of the things that neither of us addressed here today is we also have to think about drug-exposed infants. We have, I don't know the numbers, but a tremendous number of infants that are born exposed to marijuana, cocaine, and other substances, heroin, that may lead to lifelong effects for that child. And what do we do in those families? Do we allow that child just to go home? Are we going to provide services, et cetera? Knowing that those children are at great risk. And we see so many of those children come back subsequently abused. So I apologize, more questions than answers.
No, thank you.
Yes. I think if I were to look at the comorbidities of child maltreatment, the top ones, besides poverty, and we joke sometimes if we could just cure poverty, we would have this licked. And there's something to be said about that aspect, that the opportunities that children have to grow and to thrive are not equal in our society. And when we look at those that have the least resources, they're the most challenged in risks when we're talking about child maltreatment. With that said, the two issues besides substance use as being one of the bigger issues is domestic violence or intimate partner violence. And I think if we could address and have ways in which we are recognizing that as part of the equation and providing good interventions and or supports around those issues. And again, I think it stems to some degree to the legislative side of things and the statutes that relate to this issue and how our Child Protective Service agencies function around, say, domestic violence. We need to ensure that that is part of the equation, but that we don't then re-victimize the mother if in fact that is a significant aspect to the process in determining child maltreatment, that we have a way of addressing both victims. And that's something that I think a lot of states are looking at. And I am very encouraged when I look at the data and I look at the research, when we look at this particular issue, there's some progress, significant progress that's been made in child protection nationally, if you just look at it on the whole, in having a better understanding of intimate partner violence as it relates to child abuse and how that affects the decision-making for the system.
Can I make one comment? I would say we did a study about 6 years ago, and it was actually a survey of Child Protective Services workers. And what we were looking for is how Child Protective Services workers make decisions about evaluations of other children who are living in the home with an abused child. And we surveyed, it was one of our fellows projects, multiple CPS agencies. And we asked them with a list of 10 different things, which is one of the questions, if you had a child and you were assessing the home, because the home visit was very important, which of these things are most important in making you think the other children may be at risk? And the two least important of the 10 were substance abuse and domestic violence. And I think the reason is, and what the caseworkers told us, was it's so prevalent in every family they see that they don't even use it in order to assess variability in race. And I was just so amazed by that. I mean, I understand there are multiple important things, but for those to be 9 and 10 were just so eye-opening. So I think it points to exactly what you're saying, but also it's not just these are so prevalent, but they're absolutely linked to risk.
One other quick question. I was struck by what both of you had to say about your relationship with CPS and Child Protective Services. And, drawing parallel to some of my own experiences in life, I've found that when I don't understand a system or when I'm frustrated with a system at the points of intersection, it can really be helpful to do cross-training, to sit down in the same room with these folks, to get to know them at a personal level and to understand, perhaps they're a little frustrated with you sometimes as well. And so my question is this: have either of you done that, and do you believe that it is something that we really ought to be emphasizing?
Also, yes. I remember when I first started this work, the intimidation when a police officer would come into the emergency department and, vice versa, and the tensions that would build, or conversations between children and youth workers, and we didn't quite know what each other needed or wanted, and and again, tensions would build. Of course, individually have gotten past that because I do this every single day of my life, and I have probably more special victims detectives and DHS and Bucks County workers' cell phone numbers in my cell phone than I do family members. So we have developed those relationships. What I've done at the hospital is try to teach that same concept, that we are in this together, and that is, it is each other's role to educate one another on both an individual case and on child abuse and neglect issues in general. And we have had many trainings at St. Christopher's, both by myself and other physicians, but also by special victims detectives, DHS workers, et cetera. And I also go out into the community to do the same. And I think that has been tremendously helpful in developing relationships, reducing the barriers to good communication. And I think that is probably, good communication is probably the most important thing that we can encourage to improve the outcomes of these cases.
And similarly, I think all of us do a fair amount of outreach, education, cross-discipline education. I had an extensive involvement of that in Ohio, and in my early time here I've already had multiple presentations specifically to child advocacy centers which have child protection, the DAs, and law enforcement all at the table. And in fact, we just a couple months ago, with one of our county child advocacy centers, was awarded a grant from the National Children's Alliance to do that very issue, to provide regular education around a variety of topics with the purposes of trying to bridge some of those gaps. I think relationships are key. I think relationships, like a marriage, takes work every day, and if you neglect it, you find yourself with challenges along the way in effectively communicating. And I think in the context of our relationships with our partners in these other disciplines, it requires ongoing, regular engagement, in-person engagement, communication, and being willing to agree to disagree. And I think that's an important piece. Being willing to say, I don't fully understand your world, but I want to invest to understand it. And often that's what we're communicating with our physician colleagues when there's a degree of frustration. They don't have a sense as to what the limits are of a child protective service worker making a determination, precisely what we're talking about this morning, or what the burden of proof is for an arrest warrant if a crime has been entertained as being potentially committed, and what that really means in the practicality of what they see. Unfortunately, TV does not help in any of what we're talking about here, and that's usually their only perspective without having a little reality with the kind of communication that we provide to our colleagues.
I just want to add one thing. I'm also involved in a program with the Pennsylvania chapter of the American Academy of Pediatrics called EPIC Scan, and in that program we do mandated reporter training in physician settings, in medical settings. And the main tenet of that is that a physician and a children and youth caseworker do the presentation together to help bridge that gap and to help physicians and other providers understand the role that the caseworker plays and have that caseworker in front of them so they can then ask questions. And that has been a tremendously successful program that I would recommend you take a look at.
You know, I think the challenge that we're going to have is to transfer as much as we can the passion that you two folks have to 67 counties with a very, very different makeup, as I'm sure you realize, because I think the work that you're doing in that regard is really, really critical.
In my work with Prevent Child Abuse Pennsylvania, of course, there was initially a lot of concern, was this necessary? How are you going to pull this off in this economy, et cetera? But everyone that we have talked to If you start to have the conversation, there's no one that has disagreed that this is an incredibly important issue, it needs to be addressed, and that we have to focus on prevention. So I think the more we talk about it, the more successful we will be.
If I could just add one thing and put a plug in for technology. I think that in healthcare, we are behind the curve to other workforces with regard to how we utilize technology to improve the efficiency of our work. I think this is an area potentially of opportunity, an investment in the technology to provide webinars could really expand our ability to provide these kinds of educational outreaches in a way that we could never do amongst the however many, I think there's 8 or so child abuse pediatrics physicians in the state of Pennsylvania to have that kind of impact. Use of technology might be a means of accomplishing that a little, or getting closer to that.
And of course, healthcare is only secondary to the government and use of technology.
I want to thank you. It was very refreshing is probably not a good word, but certainly confirming of a lot of things that a lot of us already know. It was reinforcing what we believe, and that gives us power to go forward. And it's very energizing for you both to come in and say, let's talk about putting children first. And we seem to drop the ball sometimes in the system. And I also, years ago, I started, I don't know if I want to call it a pet project, but a focus on infant drug exposure and fetal alcohol syndrome. And the legislature, with some prompting, changed the CPSL to require hospitals to report those drug babies. And so I guess the question I have surrounds that, first of all. Are you seeing your colleagues, I know you said there was reluctance as mandated reporters to report abuse. Are you seeing hospitals and your colleagues making the reports of the drug babies, drug infants?
We routinely report, but there's a lot of frustration around the response and frustration about cases where the practitioners don't feel that the child is safe going home with the family, but yet they still do.
And how are you receiving your feedback, and can you enlighten us how that process works a little bit? Because I agree with you from my insight experiences that there is a significant issue there.
Well, regrettably, I haven't worked in the well baby nursery or the NICU recently, so I get only the feedback from the practitioners that do. And there's not often a lot of feedback, and that's one of the frustrations that medical providers experience, not knowing what the outcome is. All they know is that the child's still home, and from their purview, they're like, well, what did I call for? I don't even know what had happened. And I know, and I teach that mandated reporters are welcome to call and get some feedback, but I think it would be incredibly helpful to have a more automatic feedback loop, and that would probably decrease some of the hesitation of providers to report in the future.
And I guess along those lines, are you and your colleagues aware that you can ask when you make your report to receive something in writing as far as feedback of the outcome of the child abuse investigation?
Yeah, I'm sorry, what is the question?
Are you aware that you can make that request?
Oh, yes.
Are you getting that feedback at the conclusion of the CPS investigation?
And I do not get any feedback automatically. I only get feedback personally if I happen to be testifying in a case, whether it's on the family court end or the criminal end, unless we request it. So unless I happen to have a conversation with one of the workers or one of the lawyers, the feedback does not happen automatically. I am aware that we are, I can't think of the word, that we can get that feedback, but I have had experiences, as have other physicians in my institution, had the experience that when they call to get feedback, they're not given it because the worker is misinformed and doesn't know that they could provide that feedback.
And I appreciate that question, and I think that it was something that I had been thinking about as well, and it relates to the communication back to the report. And were we to have a more efficient or a consistent way of providing that feedback in a way that is not so bureaucratically described, where it makes no sense to the physician. And I use that term, and I want to just describe any time a physician is called to appear in court, that is probably the most anxiety-provoking thing for a physician to be asked to do. And I think that by virtue of that, there's this great aversion to that whole process. I think similarly, when we look at the process of reporting and really not having any sense of what that really means in the end, and then getting a letter that it was unfounded, and that's all you get. I think if there were a way to create language, and we're now looking at texts that are pre-printed text within our electronic health system records that would sort of provide a little warmer and more detail that would effectively communicate why the decision was made, so that it might be a step to improve that relationship and improve the ability and communication between the mandated reporter and the final disposition. The question is, does it happen if we're requiring the mandated reporter to check a box or make some indication for wanting feedback? I think that it should be automated, to be honest, and that would be my recommendation. If there was a way to do that, I think would potentially go a long way in improving some of that dynamic.
I wanted to say something about language. It made me think of something else. And when you look at the child line tagline, it's fraught with words that people are going to shy away from. To report a suspicion of child abuse and neglect, call. And we need to think about reframing even just that simple sentence and the way we think about protection in general. And maybe it should be something more like, to help a child who may be the victim of abuse and neglect, call. And as we proceed and think about protection, we need to think about the way we're framing things, wording things, et cetera, to soften it a bit.
Jason, I can tell you, we do get them. The forms are exactly as you said. You get, this is indicated, not indicated services. Well, you have to understand, like in our county, 97% of the cases are unfounded. So every one of my letters looks exactly the same. It's checked, unfounded. And so I think a lot of the frustration is exactly as you said, is it communication? If I refer a patient for failure to thrive, and the patient then doesn't come back to my office to find out if they're growing, CPS says to me, I can't tell you, right? Because all they can tell me is it's unfounded, but they can't tell me, is the child getting health care somewhere else? So the communication barrier is very one way, and that's been a big barrier that we can tell CYF, but they can't tell us anything other than those exact words, unfounded or founded. And virtually always, it's gonna be unfounded, so.
Okay, Bev.
Thank you. Dr. Berger, I just wanted to respond to that. Make sure that you are aware that they can tell you, and maybe that's a common misperception that they cannot share. They can make you part of a MDT, case-specific MDT regarding that child, and they can share all information with you. So I'm not quite sure if all the children youth agencies understand that, but if you have worked child, you are owed that information.
So I think this gets exactly to your issue is consistency.
Exactly.
So you're absolutely right. That in my own county, we're part of an MDT. There's never that issue. When you go beyond sometimes your own county, there may be misinformation, but I think it gets exactly back to consistency. And
I
from
agree
one
with you, it
county to
does.
another,
And Bev, maybe that's something we can work on immediately through the solicitors and the administrators to remedy until we get this task
Absolutely.
force is done.
But I want to make a comment as well. I think it's much more than just getting feedback about the outcome of a case, because in my experience, in the work that we've done for many, many years, we are mandated reporters as physicians. But then, if you're, as a mandated reporter, you're just handing a case off to child welfare and maybe the police for investigation, but you don't have ongoing input into how your report is interpreted, and what you're saying, what it actually means, what the limitations are, you can sometimes get very bad outcomes on the other end. So, when we talk about mandated reporting, I'm thinking, well, maybe we need like mandated cooperative investigation or some other mandate so that the communication is not at the reporting beginning and at the what was the outcome end. Because as physicians, we understand that we're a piece of this puzzle. We are not the puzzle, but we often have some critical pieces, just as child welfare has critical pieces and the police have critical pieces. And, I can't even count, I just can't even count the number of cases where decisions are made that are incorrect because people are not sharing the proper information.
Just switching gears if I can, to focus, there's a piece of legislation out there, House Bill, I think it's 1264, deals with expert testimony. Have you and your colleagues had any frustration in your ability to be qualified to testify for whatever reason and present evidence in the case?
I've never had an experience where I was not qualified. I did have one experience where the defense attorney and judge were hesitant to qualify me because I had not personally seen the child and had only reviewed the records and photos, and that was quite frustrating. They were using a statute in regard to laboratory technicians, and that if you were going to bring in laboratory evidence, you had to have the actual technician who did the test to testify, and they used that and tried to expand that to physicians.
Beyond I don't know, I could turn to the judge here. I certainly believe you'd be easily qualified as expert. The follow-up question would be, have you had problems getting in any types of evidence after you've been qualified as an expert?
Lots.
Bringing in, yes.
And can you just give us some examples? Because I think that's one of the things that we would like to look at to address, and that's what this House bill that I've described is aimed to do, is change
Types of
the ability to
evidence,
get in
yes.
evidence.
Previous injuries to the child, previous investigations. Oh, goodness, what else?
I think some of the family social risk factors, sometimes there's certain issues there that may be limited in terms of scope of what you're able to testify on.
Medical history that was provided to us when the child was first brought to the emergency department or admitted to the hospital, that if I am referring to what the mother, for example, told us might have happened to cause the injuries, that has been, I've had many experiences where we had difficulty bringing that in because of the hearsay rule. I've had other cases where we had difficulty bringing in medical records at all.
So I would like to just add to that a little bit, because I have had some experience in the courtroom. And I think, I understand as a doctor that there are laws, and that there are laws that you're innocent until proven guilty. And I understand that you can't just bring all past bad acts about somebody into a courtroom to prove that they're guilty of some, current allegation, et cetera. But as a doctor, I think probably the greatest frustration that I have in a courtroom in presenting the medical evidence that a child was a victim of abuse is not being able to talk about all of the injuries that I'm seeing on the child. Because one of the ways in medicine, and I try to educate people about this all the time, one of the ways that we make a diagnosis in medicine is not by looking at today's complaint, but looking at today's complaint in association with all of the other complaints. You don't just look at the headache, you have to look at the headache and the fever and the rash so you don't only look at the subdural, you have to look at the old bruises and the fractures that are healing, et cetera, et cetera. And the limitations sometimes in courtrooms on being able to bring those old injuries in to assist in that's how we make a diagnosis of abuse. It may not be this one burn, but it may be this burn plus all the old things I'm seeing that tell me, and that can be very detrimental and difficult in a courtroom, and I'm sure the judges and the lawyers will have something to say about that. Okay.
That shouldn't be a problem.
But
If those are things, that's a matter of judicial education. If those are things that you rely upon as an expert particularly as a trained physician.
But you can imagine how they are limited in the courtroom. I mean, they are.
Well, I don't have a courtroom anymore, but,
Well,
but,
yeah. Well, but when
Judge,
you
I don't
did,
know
Your
if you'd
Honor.
like to comment.
I do, and it would be allowed in, so.
Yeah, that's it. I mean, one of the, and I'm hearing some, we every once in a while stray over into the, well, this case happened and the child was returned to the parents, or, there's malpractice in every profession. And I'm very hesitant to judge judges or lawyers, or I'm sure you're hesitant to judge doctors unless you know exactly what that physician is being presented with. But I do hear things that make my hair fall out, and
I think the doc.
are inexplicable.
I think to Dr. Christian's point, it's establishing the foundation of how one makes a diagnosis.